I'd like to introduce today's topic. So as you can sort of understand, we're providing you with a refresher from the title of AB 1825 compliance requirements, as well as an overview on sexual harassment, legal implications, and the importance of training in this area. To address this topic today, I have two people here that are particularly qualified to present on the issues. We have Douglas Kelly, which is Everfi's head of legal editorial. Welcome, Douglas.
Thank you, Michele.
Thanks for being with us, Douglas. And then we have Ann Norman, who's our VP of Corporate Compliance. Welcome, Ann, and thanks for being with us today.
Hi, everybody.
Coming through perfect, Ann, and why don't you start us with the topic?
Sure. So why don't we do a quick review of the agenda? We've got a very packed 30 minutes, so let's get started. Our goal for today is not to sit here and read you what's required under AB 1825. That is certainly something you can do yourself, but rather to give you an overview as well as some additional insight. And as Michele said, we will be sending a summary, so you'll have plenty to look at following the webinar, but we're really going to focus in on four main areas today. We are going to hit the highlights as far as a refresher of AB 1825, which for many organizations really is top of mind only once every other year, so it's good to get a refresher, but more importantly to talk about some of the newer additions, such as AB 2053, and then the reporting requirements that were added last year. From there, we're going to go on and talk about why it is still important to have regular, effective training. As the numbers will show from the EEOC demonstrate, workplace harassment is still unfortunately pervasive in the workplace. And regardless of meeting legal requirements, it's important to have effective training in order to establish a positive company culture. From there, we will talk about some of the trends in 2017 that we're anticipating that you need to keep an eye out for. And then the last part of our webinar will be an overview of our workplace harassment training course. So for those of you not familiar with Everfi, you may know us as Law Room. We actually specialize in e-learning, which is one of the accepted modalities of training to comply with AB 1825. So we'll be giving you highlights of how we comply with that requirement, and then we'll open it up to any final questions. So with that, I'm going to turn it over to our head legal editor, Doug Kelly.
Great. Thank you, Ann. Good morning, everyone. I am a California licensed attorney and former discrimination and harassment litigator. I now spend my time researching and writing on how to make the workplace better from a compliance and culture perspective. So Ann asked me to hop on and briefly talk about AB 1825. And my goal here, as always, is just to give you the facts and an objective interpretation of the law. And then I'm ethically obligated to say that what I say in this webinar cannot constitute legal advice. For non-lawyers on the call, I recommend you contact your legal team or outside counsel for legal advice if you have any questions. All right, let's get started. So what you're going to see is statistics from the June 2016 EEOC report. It was a report released on sexual harassment, summarizing extensive research they did. My colleague did a webinar about this, and it is available, so please ask Ann if you're interested. Here, I just pulled stats on the types of harassment claims out there, where it shows that sex-based harassment was by far the most populous out of all of them. In particular, 12,600 represents the number of charges of sex-based harassment filed in 2015 with the EEOC. So as you know, you must file with the agency before filing a lawsuit. So to me, this indicates that people felt they had no other choice than to start litigation. And that's going to dovetail into the trends we're going to get into later in this webinar. More stats for you, 4,822. So these are the number of charges of sexual harassment filed with the DFEH in 2015. For a point of reference, in 2012, the number was 3,163. So nobody likes to do math, so that's a 34% increase since 2012. So it's still a big number. And by bringing these statistics, the point isn't to create scare tactics. That's not what we do here, but here's what I think is happening. I think there's a perception that sexual harassment is going away or it's less common or people are understanding it better. but I think it's just more subtle nowadays. Things like bias and power dynamics are more relevant in the discussion. And I'm going to get into that too later. So we have AB 1825. There's a lot of technical requirements. I'm going to go over ones specifically identified in the 2016 FIHA regulations that came out last year. Let's go over some milestones. So AB 1825 in its purest form requires employers with 50 or more employees to provide 2 hours of sexual harassment training every 2 years to all supervisors. It must include training on abusive conduct as well. And this matches what I found in my practice is, a lot of employees complain about bullies or abusive bosses, but it wasn't always illegal or sex-based. So the training hoped to identify the type of conduct and try and stop it. And finally, California regulators tweaked AB 1825 last year with the regulation update. Who must be trained and who must train? Employers are 50 or more employees. Not all of those employees technically have to live or be working in California. Also, employees includes part-time and temporary workers, even ones you get from a staffing company. And you must train all supervisors. So for the purposes of the FIHA, supervisors basically have the authority to fire subordinates and exercise independent judgment in their jobs. It's certainly not that simple. It's a complicated legal question, but that's really just the gist of who's going to constitute the type of work duties that create a supervisor, and those need to take the training under the law. And finally, with new hires, so if you promote somebody to a supervisor position, they must be trained within 6 months of hire. Also, if you're a smaller company and you're expanding to 50 employees or more, you must roll out the training within 6 months. And below are the sites where I get it from in both the FIHA and then the implementing regulations. And so AB 1825 prescribes different ways to train in the workplace. It can be live, e-learning, or webinar styles. Each have separate requirements. For e-learning, an instructional designer and trainer, like an attorney, must develop the course, and the trainer must be available for questions and answer them within 2 days. So the FIHA amendments make 2 big changes I want to highlight. One is that they talk about behavior that may constitute harassment, discrimination, and retaliation. That needs to be built into the course. It's not just actions anymore. It's not this vague concept of illegal things. They're actually using the word behavior. And another clarification is that a supervisor is obligated to report sexual harassment. They want to make that clear. That was already under the law, but making it explicit shows that it kind of takes an all-hands-on-deck approach to tackling sexual harassment in the workplace. So this next slide pulls language from the regulation themselves. Training must pose questions to the audience, develop actual skills, and use hypotheticals. I believe Anne will get into what that will look like, but I think this is the sort of the level of interactivity that needs to be in e-learning. And additionally, these are examples of the additional types of interactivity that training should include or can include. This list isn't exhaustive, and it's certainly you don't have to provide all of these in training. Instead, these are different ways to engage a person beyond just reading the law, a summary of the law, or the summary of all the requirements in AB 1825, right? They want to really try and get people to learn from these proscripts. Record keeping. This is a big change with the amendments last year. So you as an employer must keep records of this training for at least 2 years after completion. This is an employer's obligation, no one else's. There has been some question about the copy of written or recorded training materials. Some ask whether it must be printed out, and I personally don't think so. So with new sexual harassment policies, the law regulates how they must be disseminated, and it can be all electronic. So I think that would apply to the different types of training materials you have to keep recorded. We're in an electronic world, and I think the amendments recognize that. There's a lot of training content requirements. I've listed all the requirements here, and it's going to be available in the document Anne's going to give to you after the webinar, but I'm going to go over ones I think are most important for 2017. This really speaks to trends and things to look out for. First is what type of conduct constitutes sexual harassment. The law is really looking at behavior. You also don't have to show sexual interest, and you don't have to be the target of unwanted advances to claim a hostile work environment. And also a recent Pennsylvania case shows that a blue-collar workplace where it's common to make jokes and create lewd pictures is definitely no excuse. And also gender in all its forms, including gender identity and expression and transgender, is being attacked and targeted, right? It's targeting someone's sex. That's the big thrust of the law nowadays. And so what this all means is it's very, very broad. A lot of different conduct can constitute sexual harassment. Second is the supervisor's obligation to report harassment, discrimination, and retaliation. This is always a requirement under the law, but it's being made explicit because what happens is that supervisors should really understand that they're representatives of the company and that anything they see when they're on notice, the employer is going to be vicariously liable for those actions. And so having them understand their obligations to stop and resolve sexual harassment, at least help in the resolving of it, and certainly report it to the appropriate people. And then finally, strategies to prevent and remedy suspect behavior in the workplace. The language before used to say investigation, that you as an employer had to investigate, but these newest amendments blow this out. It's not just an investigation and then you're done. California wants true resolution from beginning to end. If there's a problem, you actually fix it, and you make that clear. No window dressing or no relying on old ways of doing things. And it's going to be particular to your particular work environment and how your workplace functions. And then here's another list of requirements. I'm going to highlight resources for victims of sexual harassment. So this isn't new. It's been part of the regulation, AB 1825. But the FEHA regulations also change what must be in your sexual harassment policy. For example, you have to make it clear a subordinate doesn't have to report to the supervisor to make a claim of sexual harassment. And the sexual harassment policy will prescribe very clear instructions on what a victim should do. So I identify that because we're not talking about the sexual harassment policy explicitly here, but they're both related in that regard. We really see this coming together of an employer really stomping out any forms or allegations or claims of sexual harassment before they arise to litigation or something truly bad. Optional content. So this is optional but recommended content. I need to make clear that the regulations don't make this clear. This is personally what I think is happening out there based on what I read and see. Mentioning other forms of harassment and discrimination is a possibility. For example, talking even about disability. Disability, even nowadays, is still a big issue I see employers struggling with because it's a really difficult legal topic. But that's one way is, if you come from an inclusion and diversity standpoint, harassment training may include broader forms of discrimination. Second is bias. So the big buzzword for the past few years has been unconscious bias or implicit bias and how that affects our actions from judges to juries to people in the workplace. One thing to highlight here, I think it's really easy to look at unconscious bias and think that it's not our fault. But I think bias is actually a lot more explicit than we like to admit it is. I think it's something that happens a lot, and until we're able to identify it, it contributes to sort of inequalities in the workplace, not necessarily overt claims of discrimination or harassment, but inequalities that make the workplace not so great for a lot of people. And then finally, these broader concepts, almost philosophical concepts and sociological concepts of power and privilege are affecting the workplace. I bring that up because Canada actually makes this pretty explicit in their laws. They talk about the power dynamic between a supervisor and their subordinate or an employee. And that's going to naturally involve this script of that could lead to sexual harassment or very concerning behavior. And so these are all things that a sexual harassment training, or you as an employer, can add in addition to traditional AB 1825 training to really, again, achieve the spirit of what all these changes are sort of recommending, as stomping out behavior that could lead to sexual harassment or could lead to illegal actions. And then trends. This is what I think we're going to see in 2017. So gender has been huge in the past year, and society has a way of affecting the workplace. So we saw the Women's March happen all across the nation. We also are seeing more claims of unequal pay being filed by women because they're not being paid as much as their male counterparts. And that litigation is happening right now. And so again, it's all about gender. Second is this concept of sexual orientation and sex stereotyping. So the Hively case, I'm sorry about the typo, folks, but it was Posner saying, like, who will be hurt, with having protecting sexual orientation. And sort of what people need to know from a national perspective outside of California is sex stereotyping is still a form of gender discrimination, and it can be sexual harassment. You don't have to necessarily implicate someone's sexual orientation for it still to be illegal on a national level. And I bring all of this up because courts are really defining and trying to fit sexual orientation into the federal landscape. For all of you in California, certainly this is prescribed, it's very much in the law. But I think that's a trend we're going to be seeing, this balance between sex stereotyping. And then finally, talking about culture, another buzzword. People use this all the time, and we've written a lot of information about this. We did a webinar on compliance culture. And what this basically means is, having a culture to where naturally employees understand the company's values, and they understand how those match up with outside laws. And so when people go about their everyday business as workers, their conduct is full of integrity. They are going to naturally lead to compliant behavior. They're going to naturally and intuitively understand what certain conduct could lead to trouble or to lead to things going wrong in the workplace. So a lot of scholarship out there. I recommend asking Anne for the webinar on compliance culture if you're interested in that. But so I think what these all say is there's these really murky standards that are arising as far as how the law is applied to real life as we see it in 2017. And I think that's, if there's one big trend or one theme that we see, is the less overt nature of sexual harassment and sort of how an organization has to come together and tackle it. So that's what I'm seeing for 2017. I don't think it's anything groundbreaking, but it's important to remember these topics. And then with that, I'm going to kick it off to Anne. Thank you so much all for listening, and I'll stay on just in case. All right, Anne.
Great. Thanks, Doug. So what we're going to switch gears now and move on from the kind of knowledge-based portion, and we're going to talk about the Everfi solution. And just a quick note on my background. I'm somewhat new to Law Room, but I've been in the compliance and e-learning space longer than I care to admit. So I've worked with thousands of companies over my career to help them implement enterprise-wide training. And one of the main areas I've worked with organizations on is harassment and discrimination training. And I clearly remember when AB 1825 was signed into law back in 2004. And so I've seen, the trends and the evolution, and Everfi has put together a wonderful solution, and we'll talk about that in the next 10 minutes. So just a little bit about Everfi for those of you who are not familiar with us. The name Everfi may not ring or be familiar, but Everfi is one of the largest ed tech companies in the country. And their focus is really on helping schools train students, so K through 12 and then higher ed. And it's a very socially conscious company that focuses on things like sexual assault, drug and alcohol awareness, and then we also work with kids to early on to be smart with their finances. So what happened was in 2016, Law Room was actually acquired by Everfi. And what our purpose is to work with organizations to help them train their workforce. I think we all know that bullies grow up and get jobs, and that's where we come in, is to ensure that the behavior in the workplace remains compliant. So we've been doing this for quite some time. Something unique about Everfi is that we have on-staff attorneys and instructional designers. So we can respond quickly to either legal changes, changes in technology, et cetera. And with that, we keep our library extremely fresh. We've got a lot of market traction, and last year alone, we trained over 6 million employees. So in terms of speaking to the technology, which, Doug talked about the record-keeping requirement, we also have a technology platform in addition to our content. And to speak to how good it is, we received about $61 million in funding from the likes of some tech giants like Jeff Bezos, Evan Williams, and Eric Schmidt. So some of you on the call may have your own learning management system, and that's great. But Everfi also has an extremely robust learning technology platform. So what I'm going to cover in the next 5-6 minutes or so is an overview of our online training course. Now, regardless of how you're going to choose to meet this requirement, whether it's classroom or webinar or online, maybe you've got something, maybe you're looking for something, I think that what I present will be really helpful to you. The other thing I might recommend is when you do get the white paper is just kind of check the box on the requirements. Our course certainly meets and exceeds all of the required elements. You want to make sure that whatever you're doing, yours does as well. So one of the first requirements that always gets people is the 2 hours. So the training must be no less than 2 hours every other year. So with e-learning, the great thing is Everfi has built into the course a timer that, for lack of a better word, forces a person to be in the course for no less than 2 hours. So regardless of how you're doing the training, you just want to make sure you have a component or mechanism to ensure the 2-hour requirement. Doug also talked about the regs, the AB 1825 calls for interactivity. Throughout our course, we have numerous interactive exercises, skill building exercises. Now, I know this is a little difficult to see, probably because it's a screen grab and it's minimized, but in this particular scenario-based question, we ask your managers, how would you handle this particular situation? So the goal here is that we want to start doing some behavior modeling. We want the course to be relevant. It's not going to be effective if people are going through it going, what is this? And I know over the years I've been doing this, I've seen courses that the behavior was so overt, it looked more like assault than it did harassment. And that's, what we do is we address the topic realistically, because most people are what I like to refer to as likable perpetrators, meaning they're not bad people, but they need some training. And to do that, you need to really start modeling the behavior. And that is exactly what our course seeks to do. Also required is the incorporation of your workplace harassment policy. And what's great about using an e-learning solution is that we can drop your policy right in the course. So this would be, specific to you. And then you'll notice to the right, there is actually an attestation required. So the employee cannot finish this course until they have electronically certified that they've read and agreed to follow your policy. And that's very powerful information to have, but it's also, from a legal perspective, very valuable to have that. Now, back to the record keeping, if our technology platform at Everfi will track this. So if you see a designation of somebody as complete, it means that not only were they required to complete the course in its entirety, but that they also did the policy certification. So that's very important. It's a little more challenging if you're doing webinar-based or live training, because you have to have sign-in sheets and you have to have a way to do that. With ours, it does that automatically. So definitely a time saver, to say the least. Another key requirement is the ability for employees to be able to ask questions and for those to be responded to within 2 business days. One of the reasons I love working here and one of the key differentiators of the Everfi solution is what we call Ask the Instructor. And this goes back to that staff of 10 attorneys that we have in-house. And at least the last time I checked, we are the only e-learning provider that offers this, where within the course, the learner can click on the Ask the Instructor, they can enter their question, and that will be fielded by an Everfi attorney. So we actually can take those questions on for you and save you the burden of having to respond to those. And it's an incredible value add. It's something that no one else offers as far as I know, and something to consider. Now, you may also say, I want to have my people to have the ability to ask questions of me, meaning someone in my organization, and we totally encourage and respect that. So what you can also do is where we incorporate your policy, you can also add a sentence of, if you want to talk to someone in HR, or maybe you have like an employee relations line, or maybe you have a whistleblower hotline. Whatever means of points of contact or communication is absolutely fine. We talk about real world scenarios. So within our course, all of the examples and items that we talk about are actually based on real life examples. So this isn't going to be like out of left field, but rather these are things that have actually happened in the workplace. And again, back to that, keeping it realistic, addressing the subtleties of harassment, because again, it's not always just this overt, obvious to spot. It can be a lot more subtle than that. In terms of the benefits of working with a company like Everfi, one of the great things is that in outsourcing it, not only do you not really have to worry about keeping an eye on the regs and what changes, we do that for you. So in the example of AB 2053, when the requirement for abusive conduct came out, I think a lot of people were caught off guard. And what Everfi was able to do is in real time amend our course, make the updates available to our clients the day it went into effect. So you want to make sure that whatever mechanism you're using, you're able to do that. And we have just an incredible staff of people here at Everfi. The resumes of a few of our chief legal editors, one of whom you've already met here today, but just having, the comfort that not only can we field those questions, but when the requirement says, developed by experts, we've got about 30 people we can point to. So just wrapping up, one thing I would recommend you all do, or you're welcome to do, is regardless of if you're interested in our solutions or not, I absolutely welcome you to sign up for our blog. We release posts regularly, and we really focus on employment law and business and compliance issues. They're very succinct, they're timely, and it's free. So can't say that about many things anymore. So I definitely welcome you to sign up for that. And then finally, to close this out, again, I'll repeat that we will be sending out a copy of the slides. We will be sending out a white paper that lists all the regs and also explains how our course meets and exceeds those. But what I would also recommend or welcome is my number and email address is on the screen. It's not everfi.com, it's everfi.com. You are welcome to reach out to me. And if you would like to see our course, just shoot me a quick note and say, could you send me a link? And I would actually provide you access to the 2-hour course that is compliant with AB 1825, as well as a copy of our catalog. So I just want to close by saying thank you very much for being part of this. I hope it was helpful, and good luck in your 1825 endeavors. So Michele, I'm going to turn it back over to you.
Thank you, Anne. Thanks so much. And we have ended the presentation right on time. So I'd like to thank Anne and Douglas for having presented on these topics for us today, and obviously all of the people who attended, and many of you have been with us from start to finish. You're still on, and contacts are flashing on your screen. We're going to leave this open so you can take note, and you can reach out to her to follow up on the conversations we've had today. Again, one last reminder that everyone on the call is going to get a full recording of the event. You are also going to get a copy of the slide deck and a brief white paper on AB 1825 requirements. That should be available to you in the next couple of days. So thanks again for being with us, and stay tuned for our future events because we run at least 1 or 2 webinars a month. So we'd like to see you again live with us in the future. Thanks again from Everfi, and have a great rest of your day. Bye-bye.